The family did everything right, or thought they did. They found a doctor, paid for a form, and filed the application. Months later, an envelope comes back from USCIS. The N-648 is insufficient. Try again. I'm Dr. Gurpreet Padda, physician and USCIS civil surgeon in St. Louis. Today I'm going to show you the 5 mistakes that sink most disability waiver forms because every one of them is preventable. The number 1 killer, the form says dementia or major depressive disorder and stops there. A diagnosis alone is never enough. The officer reading the form is not a doctor. The law requires the physician to explain in plain everyday words exactly how the condition prevents learning, not moderate neurocognitive impairment. Instead, she cannot remember 3 simple words after 5 minutes in her own language. She cannot learn new information of any kind, so she cannot memorize civics answers. That sentence, the connection between the disease and the learning, is called the nexus. Forms live or die on it. Mistake 2, no supporting medical evidence. Mistake 3, no objective testing. A 10-minute visit with no records, no history, no prior documentation produces a form that reads like an opinion. It is not a medical finding. Officers can tell the difference. When a physician certifies that a brain cannot learn, the natural question is, how do you know? A structured cognitive assessment answers that question with numbers. In our office, we use validated instruments. I'm a MOCA certified rater, chosen to be fair to patients. We administer tests in the patient's own language through an interpreter, so a low score reflects the disease, not the language barrier. Mistake 4, the copy-paste form. Some providers complete dozens of N-648s with nearly identical language. USCIS officers are specifically trained to notice this. Recycled wording is a red flag for fraud. Every honest form is individually written because every patient is different. Mistake 5, timing. USCIS may refuse to consider a form certified more than 180 days before the filing. Families sometimes get a beautiful evaluation done and then wait a year to file. The form expires. The money and effort are wasted. Coordinate the evaluation with your filing date, ideally with your attorney. Here's how we prevent all 5 at our office. Records are reviewed before anything is scheduled. A $400 case acceptance fee credited in full toward the evaluation if we accept your case. And if the case doesn't qualify, we decline it and say why. We don't waste your time or money. The evaluation includes structured testing, a fresh, individually written explanation, and a summary on my letterhead. Fees are published. Evaluations start at $1,400, quoted before scheduling, transparent and forensic. And the sentence we put in writing, only USCIS decides whether an N-648 is sufficient. No physician can guarantee approval, and any provider who does is showing you exactly the shortcut that gets rejections. A rejected N-648 costs a family months, sometimes years, and it puts the next form under a microscope. The way to avoid that is simple. Real evidence, real testing, real explanation, honest timing. Gather your loved one's medical records, then text us at 314-886-5902 or visit immigrationexam.us. We'll tell you the truth about your case. I'm Dr. Gurpreet Padda. Do it once, do it right. Thank you for watching.